George Zimmerman's defense team says they expect to rest their case tomorrow. Zimmerman, a former Neighborhood Watch volunteer, is on trial for second-degree murder for the shooting death of 17-year-old Trayvon Martin. The judge has yet to rule on whether she'll allow the defense to show the jury a computer animation of how they say Trayvon Martin was shot. The focus today on forensics. A pathologist hired by the defense took the stand, sharing his analysis of evidence, which the defense hopes will help prove their assertion that Trayvon Martin attacked George Zimmerman and that Zimmerman shot the 17-year-old in self-defense. Gunshot wound expert Dr. Vincent DeMeo testifying that George Zimmerman's gun was up against Martin's sweatshirt when he fired that deadly shot, but that the clothing was 2 to 4 inches away from Martin's body.
Contact of the clothing indicates that this is consistent with Mr. Zimmerman's account that Mr. Martin was over him, leaning forward at the time he was shot.
But his findings called into question the prosecution, which claims Zimmerman intentionally targeted Martin as he walked in his neighborhood in Sanford, Florida last year, pointed to other possibilities.
Is it not also consistent with Mr. Martin pulling away from Zimmerman on the ground, and you would have the same angle, he's pulling away and Zimmerman shooting him at that time?
Yes.
DeMeo also explained that despite the injuries to Zimmerman's head,
I said it's indicative of a hard impact.
The evidence doesn't reveal who initiated the confrontation that ultimately led to Martin's death. The defense says they expect to be finished presenting their case tomorrow. The judge presiding over the trial ruled Monday that Zimmerman's attorneys could present evidence about how Trayvon Martin may have been high on marijuana the night he was shot to death, or at least had it in his system. State attorneys had tried to keep the information out of the trial, arguing that the amount of marijuana was minimal and would prejudice the jury. Now, for more, we're joined by Bennett Gershman. He is a professor at Pace Law School and a former prosecutor in Manhattan. While in private practice, he specialized in criminal defense litigation. He is one of the nation's leading experts on prosecutorial misconduct. Bennett, thanks so much for joining us again.
Thank you to be here.
What's your take from what you've seen of the forensics that came down today? And that's the physical machinations to see who was attacking whom at the time of the shooting?
Well, the forensics show that there was a violent encounter between Zimmerman and Trayvon Martin. I mean, that's not really disputed. And I think the evidence suggests that Trayvon Martin may have been on top of Zimmerman at one point. I think the real question is whether, even under those circumstances, Zimmerman was reasonably fearful of his life or suffering serious physical injury that allowed him to kill. And I think that's the question the jury is going to have to ask. Was Zimmerman in reasonable fear of his life or such serious injury that he needed to take the life of Trayvon Martin? I think on the evidence, the defense is doing very well. I think they're doing better than the prosecution, actually. But I think in terms of sympathy has always been with the victim, Trayvon Martin, the young boy who was killed. And I think the jury, my sense is the jury is going to go with sympathy rather than the evidence, at least in terms of a verdict, not of murder, but I think of manslaughter. And I think of manslaughter because I think they're going to reject the claim of self-defense under these facts. We call it in criminal law, we call it imperfect self-defense. Yes, there's no question that Zimmerman may have felt in fear. Okay, but the question is, was it reasonable for him to think that he needed to kill this this young man, to preserve his own life?
Folks who are watching the testimony today, they may think, well, the positioning of this, well, Trayvon Martin's on top of Zimmerman, so clearly he's the aggressor. Is that such a slam dunk, even if that positioning is correct?
No, it's not, because even if there is a physical encounter like that, you're talking about fighting with fists and pushing and shoving and striking, with blows. That does not seem to rise to the level of inflicting such serious physical injury on somebody else that would justify killing. Trayvon Martin didn't have a knife, he didn't have a gun, he didn't have a weapon, he didn't have a rock. It's a physical encounter. And so, you know, the stand your ground argument is not really relevant here. It's a question of basic self-defense. Can you take somebody else's life when somebody else is pummeling you with their fists? And I don't know of any case that would allow a self-defense claim in those circumstances. I really don't.
I want to get to the marijuana ruling by the judge because this has gotten a little bit of play in the press. What's your sense on the value of that for jurors in trying to determine Trayvon Martin's behavior or state of mind or approach?
Well, the idea there is that it would have made Trayvon Martin so more violent, more physically violent, that it would then justify George Zimmerman in thinking that this attacker was going to do terrible damage to him. I mean, that would be the argument that the defense is going to be making, that the marijuana, like intoxication, makes the aggressor, if the jury finds the aggressor is Trayvon Martin, so violent and out of control that it would cause Zimmerman to think he needs to use excessive force in order to stop this person from hurting him.
I'm curious what the rest of the panel thinks about this, just because most of the time we bring up marijuana issues on the show, it's about wider acceptance and people who've, you know, experienced it or whatnot. I don't think a lot of people would jump to the conclusion that it would make somebody more violent. I'm curious what everybody else thinks about that.
I think it just makes you question your judgment. I mean, it's not a question of violence as much as it is inhibitions being down. You may do something you wouldn't normally do under other circumstances. I'm sure the prosecution could spin it any way it wants, and so can the defense.
But they've ruled that it was such a small amount that it would have had no real impact on Trayvon Martin. I couldn't agree more with what the professor just said in terms of, I mean, let's look at this realistically. Murder 2 was out. You were never going to get Murder 2 anyway. In most of these cases that involves race, the best you get, history has shown us, is manslaughter. And I understand we can agree to disagree, but I am telling you, there is no way in the world that 6-woman jury is going to let Mr. Zimmerman walk out of that courtroom scot-free. When you consider that Trayvon Martin didn't have a weapon, you can't get around that 911 tape. You can say Trayvon Martin instigated it all you want. The 911 tape doesn't lie. No, we don't need you to do that. He does it anyway.
The stand your ground and the reasonable doubt are two things that
He
make
just said stand your ground has nothing to do with this. And that's the point I argued from day one. This has nothing to do with this has absolutely nothing to do with stand your ground.
But we'll see how both the judge and the jury feel on that when
It's the instructions, what the judge gives for
agree
instructions,
with you
and
on
if the
that.
jury can be independent enough to follow just those instructions, I would think,
And
right?
I do think, speaking of the all-female jury, the fact that you have these two mothers both making different cases is just a heartbreaking, and it's going to be fascinating to see where they come down. Who's going to say one of these poor mothers is lying? I mean, it's an awful situation, and it's, you know, one of them, or just mistaken. It's a horrible situation when you look at the fact you have an all-female jury and you have these two poor mothers both saying that's their baby on the 911 call calling for help.
Professor, I'm curious. Most of the experts we've turned to on this case so far have agreed that they think murder 2 isn't likely, manslaughter is far more likely. Why do you think that is? Is that the difficulty of proving murder 2, or do you think it's the prosecution and how they've approached this case?
No. Look, I wrote an article about this. The key element in murder 2 is you have to show a depravity. You have to show depraved indifference to human life. It's a very high standard of ill will, of malice, of hatred for somebody else. And I don't know that the evidence rises to that level of depravity. I mean, that's what the law, the element in the statute requires. And even though the courts say it's spite, it's too high a level of culpability, I think, given the fact that there is an altercation, there is a violent encounter. And I don't know that you could say that Zimmerman manifested a depraved indifference to human life when he tried to protect himself, assuming the jury sees he was trying to protect himself.
Even with the sort of following Martin around the neighborhood and the fact that this has apparently happened, not a shooting obviously, but confronting other black youths in the neighborhood over, in the months previous?
No, those are points against him, for sure. But the other side is there have been some very favorable testimony about, he's a good guy, he's trying hard to raise himself, he's an immigrant, or he's parents. I mean, there are some very sympathetic features about Zimmerman's life that would probably counterbalance the, the proof of following people and things like that. So I think that's kind of like a wash. Murder just strikes me as too excessive a charge here that I think the prosecutor felt was, the special prosecutor, needed to be brought because, I think, of public pressure. But I think at the end of the day, I think the prosecutor also thought that by bringing a murder charge, it's more likely that there's going to be a compromise on the jury to manslaughter.
I think we have a point from one of your former students.
There was one, yes. There was one interesting piece of testimony. A personal trainer of Zimmerman's testified that on a scale of strength 1 to 10, Zimmerman was a 1. Basically testified that he was a wimp, which is interesting because when you initially saw the images of the victim and of Zimmerman, you said, well, this guy's in his 20s, he's a husky guy, how could he get beat up by a 17-year-old? Typically, men have more testosterone, more man strength, and would be able to at least fight off a younger teenage person. But that testimony was interesting to say that he was basically a tomato can, and that's what it gets down to. Was he really getting pummeled? Maybe the average person wouldn't have gotten pummeled, but he was a wimp.
But if he's a wimp, then shouldn't he have stayed in the car the way the 911 operator told him to do? If he's a wimp, if he's not that strong, it would seem to me common sense says obey the directive of law enforcement.
But wouldn't that just go to show, or I guess the defense is hoping that would go to show that he really did have reason to fear for his life in a confrontation?
I think so. And I think he may have felt that this is his responsibility. He's there to protect the community, and he feels that he needs to do the things that he's trying to do. I agree with Jeannie that I think this jury is to me a prosecution jury. I really think that 6 women expressing sympathy for the victim, for the mothers who testified. I think there's a lot there that's that may be helpful to the prosecution. It's hard to read. It's always hard to read juries.
One last question. We're just about out of time. I'm sorry about this, but we've heard some concerns about what might happen with particular rulings, that there could be blowback in the community or in the wider community. Is that the kind of thing that crosses a jury's mind in a case like this, where there's the potential for reaction outside the scope of the courtroom?
I think you can't speculate, but you have to think that juries are thinking about things like that. I think so. I think they realize the enormous gravity of this case, just in terms of the national response. They know that race plays a huge role in this case, so I think they're going to feel that those extra intangibles, above and beyond the evidence.
Professor Bennett Gershman, professor at Pace Law School, thank you very much for the time. Appreciate it. We're going to take a quick break here on RFL. When we come back, we're going to take a look at how expensive it is to run for Congress these days and what the implications are both on Capitol Hill and for you at home and the laws they make on your behalf. That's next. Stay with us.